This is another immigration video update, and I want you to pay close attention. The final ruling has taken place, okay? Now, recently we talked about public charge and about who would be getting in trouble because they were on some form of government assistance. And originally, it was supposed to be anybody who was trying to change their status from legal permanent resident or change their status to legal permanent resident in the United States of America, or someone who, say, had a green card and was going to convert that green card to citizenship by applying for citizenship and going through the naturalization process. It was said that if it was found that you were on welfare or any form of government assistance for any period of time that lasted more than 12 months consecutively, then you would be denied status. And in that case, some people would actually be sent home. Now, a lot of people can breathe easy because it didn't happen like they said it would happen. However, it did happen. Now I bring you the details of what exactly happened. So it starts out like this, and I'm taking this information directly from the government website. Final rule on public charge ground of admissibility or inadmissibility, meaning the final ruling has taken place. Self-sufficiency has long been a basic principle of U.S. immigration law. Since the 1800s, Congress has put into statute that individuals are inadmissible to the United States of America if they are unable to care for themselves without becoming public charge. So in other words, if you're unable to care for yourself without ending up on welfare or having the government take care of you, then you as an immigrant was not allowed into the United States of America. It was supposed to have been that way, and it was on paper written into law since the 1800s. However, many administrations came by and they did not enforce it. So what we have had in the United States of America is a stream of people coming through from impoverished countries to live in poverty in the US and depending on government assistance, which left less money in the bank for real American citizens who needed it. Right? Under the administration of the Trump administration, he decided that that was not fair to United States American citizens, and he was going to find a way to fix it. Okay. Since 1996, federal laws have stated that foreign nationals generally must be self-sufficient. This final rule provides guidance on how to determine if someone applying for admission or adjustment of status is likely at any time to become a public charge. And the law goes like this. The primary immigration law today is the Immigration and Nationality Act of 1952. As amended, it has been amended, Section 212A4 of the INA 8 USC 1182A4. Any alien who, in the opinion of the consular office at the time of application for a visa, or in the opinion of the Attorney General at the time of application for admission or for adjustment of status, is likely at any time to become a public charge, is inadmissible. In determining whether an alien is excludable under this paragraph, the consular office of the Attorney General shall at a minimum consider the alien's age, the alien's health, the alien's family status, their assets, their resources, their financial status, their education level, and their skills. Self-sufficiency has been a basic principle of United States immigration law since this country's earliest immigration status or statutes. It continues to be the immigration policy of the United States that aliens within the nation's borders, here already on U.S. soil, must not depend on public resources to meet their needs, but rather they should rely on their own capabilities and the resources of their family members, their sponsors, the people who filed papers and backed them up to bring them here, and private organizations, whether it be churches or affiliated groups that you belong to, or take out a loan somewhere, something like that, but not on government assistance. It is also the immigration policy of the United States that the availability of public benefits not constitute an incentive for immigration to the United States. In other words, then, you're sitting somewhere in a poor country, you should never be motivated to come to the United States and live because you can collect welfare here. DHS final rule. On August 14th of 2019, the United States Department of Homeland Security published the inadmissibility on public charge grounds final rule that codifies regulations governing the application of the public charge inadmissibility ground under INA Section 212A4. On October 10th of 2018, DHS, which is Department of Homeland Security, issued a Notice of Proposed Rulemaking, NPRM, which published in the Federal Register for a 60-day comment period. DHS received and considered over 266,000 public comments before issuing this final rule. The final rule provides all the summaries and responses to all significant public comments. The final rule enables the government to better carry out provision of U.S. immigration law related to the public charge ground of inadmissibility. The final rule clarifies the factors considered when determining whether someone is likely at any time in the future to become a public charge, is inadmissible under Section 212A4 of the INA, and therefore ineligible for admission or for adjustment of status. The rule applies to applicants for admission, aliens seeking to adjust their status to that of a lawful permanent resident from within the United States. So people are going to ask, okay, who does this affect? Listen carefully. The rule applies to applicants for admission. You're wanting to come into the U.S. Aliens seeking to adjust their status to that of a lawful permanent resident from within the United States, and aliens within the United States who hold a non-immigrant visa and seek to extend their stay in the same non-immigrant classification or to change their status to a different non-immigrant classification. The final rule does not create any penalty or listen carefully. The final rule does not create any penalty or desensitive or past, current, or future receipt of public benefits by U.S. citizens or aliens who Congress have exempt from the public charge ground of inadmissibility. So there are some aliens who are just okay. They will not be affected by this, even if they have been collecting welfare or collecting government assistance. Okay? And for U.S. citizens, this does not apply to them at all. They will not be feeling any ramifications, whether it was past, current, or future use of the resources that are there. The final rule does not apply to U.S. citizens, even if the U.S. citizen is related to a non-citizen who is subject to the public charge ground of inadmissibility. The rule also does not apply to aliens whom Congress has exempt from the public charge ground in of inadmissibility, such as refugees, asylees, Afghans, and Iraqis with special immigrant visas, and certain non-immigrant trafficking and crime victims, individuals applying under the Violence Against Women Act, special immigrant juveniles, or to those who the Department of Homeland Security has granted a waiver of public charge inadmissibility. In addition, this rule also clarifies that the Department of Homeland Security will not consider the receipt of designated public benefits received by an alien who, at the time of receipt or at the time of filing the application for admission or adjustment of status or extension of stay or change of status, is enlisted in the U.S. Armed Forces or is serving in active duty or is on the ready reserve components of the United States Armed Forces, and will not consider the receipt of public benefits by the spouse and the children of such service members. Rule further provides that DHS will not consider public benefits received by children, including adopted children, who will acquire U.S. citizenship under INA Section 328 USC 1431. So, in other words, if your spouse or you are in the military or in any component of the military, to include the Ready Reserve, active National Guards, etc., Armed Forces, Navy, Marine, Air Force, so on and so forth, then you will not be affected when you go to adjust your status. They won't pull the paperwork up and say, well, you were on it. It will not affect you. And it will not affect your children either, right? And it will not affect the spouses of individuals who are. Now, similarly, Department of Homeland Security will not consider the Medicaid benefits received. 1. For treatment of emergency medical condition as services or benefits provided in connection with the Individual with Disability Education Act, as school-based services or benefits provided to individuals who are at or below the oldest age eligible for secondary education as determined under state or local law, by aliens under the age of 21, and 5, by pregnant women and by women within the 60-day period beginning on the last day of the pregnancy. So, for those who were green card holders and they took the WIC and all that other benefits that were supposed to be for unborn United States citizen children that would be born into the U.S., you don't have to worry about that. That was one of the biggest worries out there, where people were saying, but they gave that willingly and they encouraged you to go down to your local health department and take these things so you could develop or have a healthy baby develop, right? Well, you don't have to worry because you will not be affected. Now we know this is the final ruling. Department of Homeland Security will only consider public benefits received directly by the applicant, the person who is filling out the application to adjust their status. Department of Homeland Security will only consider the benefits received by that particular individual, the applicant, for the applicant's own benefits, or where the applicant is a listed beneficiary of the public benefit. So if you're on somebody's paperwork, they're collecting welfare for a house of 5 and you are one of them, then this might affect you. Department of Homeland Security will not consider public benefits received on behalf of another as a legal guardian or pursuant to a power of attorney for such a person. So if you were within the age group where your legal guardian was collecting and you were in that home as, say, someone who was under the age of an adult, which is 18, then you are not going to be held reliable or responsible for that as well. Department of Homeland Security will also not attribute receipts of a public benefit by one or more members of the applicant's household to the applicant unless the applicant is also a listed beneficiary of the public benefits. All right. And that is where the status is for the final ruling on public charge ground of inadmissibility. You can find this at uscis.gov. Okay. And uscis.gov, legal resources, final rule on public charge ground of inadmissibility. One question that is lingering is, when will the final rule go into effect? Today is September 23rd of 2019. The final rule will go into effect because it has already been passed and been made amended to be law. It will go into effect October 15th of 2019, and it will only be applied to applicants and petitions postmarked, or if applicable, submitted electronically on or after the October 15th of 2019. For further information, again, please go to US Citizenship and Immigration Services.com or uscis.gov and look up Final Rule Public Charge Ground Inadmissibility. Like, comment, share, subscribe. Leave your comment in the comment section below. Thank you for listening, and pass this information on. I'm out. Peace.